Good afternoon, everyone. Welcome. My name is Rachel Bannock. I'm the Association Director for the Illinois Mental Health Counselors. Thank you all for being here today on this timely topic, this webinar. If you are not muted, everybody should be muted upon entry, but if you can please make sure you are muted. We want to give the presenters the ability to get through the presentation. So again, thank you so much for being here. At the conclusion of the webinar, I will send you an email with some handouts
that was my
provided by Sterk.
There's
just a reminder to mute yourself, guys. Please make sure you're muted.
All right.
So at the conclusion of the webinar, I will send you a link with the handout for today's presentation. It will also include an evaluation. Please complete that evaluation and we will email you your CE certificate. So with that, I'm going to turn it over to Kelly Garver and she's going to intro today's presenters.
Hi, good afternoon, everybody. My name is Kelly Garver. I am the Business Development and Marketing Manager with Sterk Family Law Group. Sterk Family Law Group is a family law and estate planning practice located in Orland Park, and we service clients primarily in Will, Cook, and DuPage counties. We handle all matters of family law, ranging from child support, divorce, postnuptial agreements, prenups, postnups, trusts, guardianships, wills, all of that, a full basket of any family law related type of service. What's a little bit different is we do offer a unique approach, which we have through our holistic approach by using resources within our community. We've all been faced with troubled times, and in the brunt of those hard times, it's easy to feel paralyzed. So with that, Gwen years ago in her law career decided that she wanted to stand out a little bit different and use a business card from one mental health provider to start the resource center that we've established within Sterk Family Law Group. Gwendolyn J has been practicing family law since 1989 and successfully started her own firm, Sterk Family Law Group, in 2015. Gwen and our team believe in a holistic approach, like I just mentioned, to the practice of family law, and we strive to not only service a client's legal needs, but also help them manage their emotion and overall well-being. Today, we are also joined with one of our longtime resources, who is Troy Siewert. Troy Siewert is a retired 30-year law enforcement veteran and a crisis intervention team officer and coordinator, certified crisis intervention specialist, and a trained crisis negotiator. Troy launched Insightful Crisis Response LLC in 2020 to provide high quality training to individuals and organizations on how to recognize the signs and symptoms of mental illness and how to effectively respond when an individual is in crisis. And that's that. So today I did send a link over to Rachel for a Dropbox link. So there'll be some material that we're going to go over today. So it's just going to be sent to you guys as a point of reference so you guys can have it at your fingertips. Within that too, we will drop our contact information and we'll drop it both respectively for Sterk Family Law and Troy and Insightful Crisis Response. So you guys can have our contact information, but it's also found within the packet as well.
Okay, so I think we're ready to go. I'm Gwendolyn Sterk, and I'm going to do the first part of the presentation, and then Troy will take over from there. And then we're going to hold questions till the end because we want to make sure that we get through a lot of the material because I think it'll answer a lot of your questions as we go on. And hopefully that'll be a facilitation that'll work for everybody and be helpful. So obviously we know that seeing what happened in Highland Park this summer over the 4th of July weekend, as well as hearing events just recently with Great America, you know, we all get our backs up and it's just that fear of what's next going to happen and trying to figure out how we can respond and how we can work collaboratively. And I know Troy's going to go into that in depth. I'm going to do the legal piece today to kind of introduce you to what the laws are, what you should know about, and in your practice, what I think you should make available to clientele, especially family members, et cetera, if it doesn't breach your confidentiality. So we're going to start there and talk a little just about the history. And I want to talk about red flag laws in general. And in terms of a general category, what really are red flag laws for us to get started? And what it is it's a form of gun control that permits a state court to order the temporary removal of firearms from a person who they may believe present a danger to others or themselves. And it's very interesting because unlike other areas of law, I think one of the key things to think about in general with a red flag law is a danger to themselves and others. where in the past, I think a lot of our laws were focused on protecting somebody outside of the scope of the individual as well. And generally, a judge will determine it, and a gun may be returned after the expiration of the order. So these laws do not last forever. They're intended to be short-term facilitated laws. I also think it's interesting to look at, in general, what is our federal government saying about this law and where are we at? So as recently as June 25th, 2022, President Biden signed in a bipartisan gun safety bill that authorized the governments of individual states to receive grants if they enact and enforce red flag laws. So I think that that's pretty telling that these types of laws are deemed to be something that's important to know about. Now, a lot of you will need to just keep in mind that I'm going to cover two areas. I am going to cover the firearm restraining orders, and then I'm also going to talk about the areas where we get into the Firearm Owners Identification Care Act, where there's different restrictions or different availability for licensed clinical psychologists, as well as doctors and physicians under that framework. But I first want to talk about firearm restraining orders, because after doing the research and looking at how little they've been used in Illinois since they were enacted in 2019, and I will tell you, because I'm always one to think that, I would think that you guys aren't doing the same thing we aren't, because I have to tell you, I told Kelly as soon as we put this together, is we have a failure in our own firm. We don't have a brochure to hand out to people on the firearm restraining orders. So doing this lecture today and this presentation has, certainly inspired us to make sure that we're giving this information out to family members as well, even though this is something we do in the course of our work. So a firearm restraining order, what is that, and how does that differ from other remedies that might be out there? A firearm restraining order in Illinois is a civil order that allows for the temporary removal of firearms. And basically, it also deals with ammunition and firearm parts. But it does not apply to things that also could cause imminent harm, such as the use of knives or other type of weapons. So we have to keep in mind that it does have some limitations, but it does allow the parts as long as they could be assembled to make an operable firearm. It also allows for the removal of an individual firearm owner's identification card when the individual is deemed a potential danger to themselves or others. And again, look at that word, to themselves or others, which I think is really significant. And the goal of this particular law is to protect the individual from harming themselves or those around them with a firearm. And during the time period in which the order is in effect, an individual cannot purchase or possess firearms. But what's very interesting and something to keep in mind is this is not criminal charges, and it doesn't otherwise penalize the individual. And I think that's significant to know that this is a civil as compared with a criminal remedy. So that's kind of important that's out there. A firearm restraining order can be pursued, and I'm not reading off the line, I'm just giving you some general information, and we're giving you this packet of materials so that you can take that with you to reference back to it without taking a lot of notes today. A firearm restraining order can be pursued if there's various acts. It doesn't have to be one, it could be a collection of these. It doesn't have to be all of them, it could be just one of them. So if someone is found to be brandishing a firearm, if they're threatening the use of a firearm, if they are violating an order of protection, all those items can be utilized to say and to go into court to say, I think that a firearm restraining order is something that would protect me. Now, what's also important is to understand that it is a temporary relief, and the longest period of time that it can be in effect once you get a final order is 6 months. Now, I think the way the statute reads, you can move for an extension of that if there's been circumstances that allow it, but as a general rule, it's not going to go any further than 6 months from the date that the final order is entered. And what's interesting about a firearms restraining order is that it emphasizes on immediate and observed behaviors, but it does not focus at all on mental health. Meaning, certainly mental health, we all understand that it can be present, but you don't have to have a finding. The court doesn't have to look for any kind of mental health activity or mental health crisis or challenge to be present, what they can do is simply prevent firearm violence in the context that there are observed behaviors that lead to the necessity of it. And, that's, I think, goes along with the purpose that we are not trying to stigmatize, even though I hate that word because I don't think it's true. I don't think mental health is any different than high blood pressure if there's an issue. But the bottom line is that that's a problem for individuals still in our society. And within that context, the law wanted to make that very clear. Now, so we have a general understanding of what a firearm restraining order is. We next have to look at how does that differ from other remedies that existed prior to the time in 2019 when this act became effective. And what's important to know about that is this is much different than an order of protection. So an order of protection really stops the respondent or the person against whom the order was entered from certain acts and can put individual type of restraint on that individual. So for example, an order of protection can it be an order that they must cease and stop abusive acts or threats, and they can restrain the behavior of the respondent. An order of protection can enter a stay away order, meaning that they have to stay away from the victim, meaning the respondent does, or the person that they're filing the action against, or other protected persons. So for example, it could protect a minor child or somebody else that's in the household. And there's also various provisions in the act that help you deal with people that might have disabilities. It also can stop someone from contacting a victim in person or electronic means, or by electronic means. It can provide, this is an order of protection, that the person has to stay away from specific places like home, school, or work. It also, in rare circumstances, because as a practitioner, I don't see it very often, require counseling or treatment. Somebody that has to pay child support, they have to return or stay away from certain property. And the orders do allow, after notice has been given, to surrender firearms. Now, that would be on an emergency order. But the issue is that it's a lot more restrictions on what the interaction is between the individual and the respondent. So you can get more accomplished through an order of protection than you can through a firearms restraining order. And as an attorney, you have to sometimes make the decision whether or not your first concern is to get an FRO, or whether or not you're going to go for an order of protection, or if you're going to do a combination of both. So it's very interesting. But an order of protection is not intended to protect the respondent, but rather the person who seeks it, or the petitioner and the protected persons. And so that's one of the distinctions that I think is important for us to know and go about. I don't think in any way, I think that a firearms restraining order protects somebody to the extent of an order of protection. This really is a limited remedy, but the good part of the remedy is it can be the fear that that person's going to harm themselves that can get you that order entered. One of the things I encourage all of you to do after knowing all this is to have brochures for families and for different individuals in your practice groups. And what's the distinction between an order of protection? There are also stay away orders, or what we call no contact orders, where there may not be a familial relationship or even some type of dwelling together in the same household, but yet it prevents stalking and other items. And then what's the difference between an FRO? So just like we are putting together a brochure, it's my encouragement to all of you to look at getting materials. And if you need that for your practice group, our firm, it would have our firm information on it, but could provide you some of that literature for your offices to pass out. Now, we covered two items. Our next thing is we're going to talk about the difference between a firearms restraining order and the new amendment under the Firearm Owners Identification Care Act. And that is found generally under 430 ILCS 65-801. And in response to what happened, and I'm sure many of you are familiar, is Governor Pritzker and the bodies entered into what they call an emergency order effective on July 18th, 2022. And in that order, they clarified the clear and present danger, and they also allowed for the retention and use of information. I do want to illustrate to you that this emergency amendment is something that is allowed by Illinois law, but it can only be in effect for 150 days. And during the time period in which that 150 days is pending a bipartisan joint committee on administrative rules, which is a 12-member committee of our state representatives and state senators meet together to try to determine whether or not they're going to convert the emergency rule into a permanent law. Interestingly enough, August 17th, today's date is the date that they are having their meeting to discuss whether or not they're going to do this conversion. And like I said, they have 150 days to do it. And in the interim period of time, the Illinois State Police have given and certified the emergency amendment that they're going to have. And in your material, you will find the certificate of emergency amendment as well as the provisions that have been somewhat clarified. And I know that we get a lot of information or a lot of questions because a lot of you as counselors come to the next step saying, okay, am I bound and what are my responsibilities to do with regard to this law? And my answer is that the same definition still exists as to who is covered under this provision. As you're well aware, educators have a separate provision and law enforcement has a separate provision, and they report to the Illinois State Police. And if you go on the Illinois State Police site, you can find the form that's required for educators or law enforcement to report if they believe it's called a clear and present danger report, and then there can be actions from there. That is untrue for your world. So in your world with mental health professionals, physicians or clinical psychologists have to notify the Department of Human Services of the state of Illinois, and then they take the action from there. So that's one of the things I want to make sure that you understand, that in your community, you report differently, number one. But number two, the definition was not expanded, and licensed clinical psychologists as defined under Illinois law. So a lot of individuals who are professionals in mental health aren't covered or protected. Now, we are hearing that a lot of people say, well, it's our responsibility to take some action when we feel that there is something that's going on. And what do we do if we are not protected? Because if you'll recall, Illinois law under the Firearms Identification Care Act does provide an exemption for some type of insulation from liability and protection from the disclosure if you are covered under their definition. But my concern is, as a practitioner, that unless you're a physician or a licensed clinical psychologist, that protection doesn't exist for you. So if you feel that you have an emergency that has come up, my suggestion to start with is to contact your carrier about what they believe the protection is, because you certainly do not want to get yourself into a violation of confidentiality. And if you feel that that's a risk that you want to take, my urgency to you is to call your carrier as to how you're going to reveal that. I do want to cover what they did with regard to clear and present danger, because I think that it was very interesting that they changed some of the rules in terms of the definition of the clear and present danger to remove the terms that it had to be actual, impending, or an imminent threat of substantial bodily harm to themselves or another person. What they did do is that they made the definitions much broader, and as a result, I think that you don't have to have that imminence that you had to have before. And I think that that act is clearly much more friendly in terms of the circumstances under which you can report. And so I think they brought the definition much broader. And it says that if you can report someone who demonstrates threatening physical or verbal behavior, such as violent, suicidal, or assaultive threats, actions, or other behavior as determined by a physician, clinical psychologist, qualified examiner, school administrator, or law enforcement physician. So I think that communicating that is much a broader definition and gives some insulatory protection for that. The other part of that rule change, obviously, is that it allows the Illinois State Police, once they have this information, to retain it for future use. And we'll see how long, it's not clear to me how long they can utilize that if that's an indefinite, but it certainly would give rise to notice and certain circumstances that I think we've already seen in society would change as a result of that modification. So I do think that those are important things within that context. So that's covering just in general the Firearms Owners Identification Care Act changes. I do want to get back to the firearm order that can be restraining order that can be there, because a lot of people are questioning what does it look like, because I think that families, and one of the things we want to do is have all of us educate family members as to what is it that they can do, because clearly they have the most information in many cases, and you need to be familiar about how to direct them. First of all is you file in a county where the respondent resides, but interestingly, this law gives an exception to that. So you don't have to go in and prove jurisdiction. Jurisdiction refers to the power of the court to make a decision. And in that case, the law can be triggered against a non-resident of Illinois as long as that person's had minimum contacts within the state. And I think that's important to know, because a lot of families get confused. Hey, they're in the state now, but they don't live here permanently. I still think that you can pursue it. There are no fees to file this, and all you have to do is go to the court and file your first initial petition. There are restrictions on who can file a firearms restraining order. Is that it can be a family member, a spouse, a parent, a child, a stepchild, or any other person related and who shares a dwelling with someone. So I think that that's important to know. Also, law enforcement officers can seek these types of orders. And the requirement for these orders is very broad, just like it is for now the new definition. I even think it's broader. The respondent only has to pose an immediate and present danger of causing personal injury to himself, herself, or others. And immediate and present danger can be a very broad definition, which can get you into court very easily. Now, what is it that you do when you file that firearms restraining order? And the answer is that you have to file a petition, and in our material today, you'll see that we give you forms. There is an emergency firearms order, which can be good for up to 14 days. And then the other type of order that can be there is one that it can last for 6 months after notice has been served. And there's also the availability of an interim order as well. So that's what a 6-month firearm restraining order looks like. She's showing you the emergency firearm restraining order. We're giving you these forms from Cook County, so you have an example of what it looks like. Now, at that, we already talked about things that the court can consider, but in terms of the petition itself, there is a very limited space. And I'm going to tell you one of the aggravating things for people in just what I would call unrepresented litigants going into court is the form itself really only has a very limited space to give an explanation of what happened. But I always tell individuals, you see, you're going to check the box. If you can go back up, Kelly, you're going to check the box if there's other factors or kinds of cases that are pending. So for example, a order protection, if there's a divorce, a parentage, or custody matter, if there's a stalking order, so you check that box. But if you can go down, Kelly, there's a very limited space here. And this is more of a practical tip for clientele that we're giving this information to than anything else. Do you see specific details for the request? It's a very limited space there to fill in. And a lot of times unrepresented litigants go in and they see what they were called domestic violence advocates, but it can just be a court advocate to help them fill out these forms. And they say, well, you can't go beyond what's in this box. I always tell people, bring your typewritten list so that you can either attach it to the petition or tender it to the judge, because you're going to want to tell the court whether there's been a recent threat of active violence, whether there's a pattern of violent threats or acts, whether there's any evidence of abuse of controlled substances or alcohol, whether there's any prior felony arrest, whether or not there's been a violation of an order of protection or an emergency order of protection, if there's a history of use or attempted use of physical or really threatening any kind of physical force. So to get that in the box as a practical matter becomes very difficult, but all these items need to be filled out and presented in that material itself. What the firearms restraining order will do is something I'm going to pass over in a few minutes for Troy to talk about in detail. But basically, it can be a surrender of the firearms, and then he'll talk about what's going to happen in terms of the police going to enforce these orders. Now, what is a little different about this and what people become concerned about from a family member perspective is they're naming themselves as the petitioner, right? And they're listing the protected persons. And just like in an order of protection, you have to have a petitioner. So if it is a family member, they put themselves out on the line. If an emergency order is entered, that order then will be returnable, where the respondent will have an opportunity to ask the court to find that there isn't a danger such that this order is necessary. So it is something that people might hesitate to do, but on the flip side of it is it's a very important remedy that can occur because you can remove the firearms. And in some ways, on certain emergency situations, although it doesn't prevent contact, it can be more useful than an order of protection. And that's why I'm saying lawyers and litigants need to have that discussion if they are represented about which ones to go for. But if you have clientele who are in your office and maybe a family member calls or they, want to have more information, I don't think without violating certain laws, you can pass out literature to people to say these are the available remedies, and you can refer them to the circuit court locally. They can go to the clerk's office and the clerk will direct them generally to an advocate who will help them fill out the forms. However, all that being said, I'm a pragmatist, and the reality is when you get into court, this is only law since 2019. Not everybody's familiar with it. And you really have to say, I'm here, I want to go before a judge. Because unfortunately, while I think things are improving, I don't think that there is this attitude in every circumstance where let's help you, hold your hand and walk you through this process. They do need to have some kind of advocacy and make sure that they have some information to know how they navigate through. That's why in circling back, I do think it's important that you give information out and give them the information and ability to go through and to get into before the court. Generally, the courts are going to hear the information on an emergency. The rules of evidence are supposed to apply, but they can get a lot of information in that time, oftentimes with violations of hearsay, etc. But if you do get a lawyer coming back to represent a respondent on a firearms restraining order, then some of those rules of evidence are going to apply, and it might be a little more difficult to get an extension of that order. The reality is that doesn't happen very often, but it can happen. And so I don't want people to go in there and think, well, they can't be represented by an attorney, nor can the respondent. That's not true. Although the court system is doing its best to become very friendly and very oriented towards unrepresented litigants, this is a situation where these things can get somewhat complex, although they did try to simplify the process and move it forward. So there does have to be service of the order. There are certain due process rights that are listed that we have provided in your material as to what will go forward for everyone to have that context. It will take more than one court appearances. And if you don't have any, let's change the scenario, the judge denies the emergency. There are certain circumstances where the judge may deny it on an emergency basis, and he or she may then say, well, you can return for a full hearing thereafter. They may grant it. And if they issue the restraining order, then a search warrant will occur. If the gun material is there, which Troy will talk about in a minute, then we're good for 14 days and we have to be back into court for that extension hearing as we go forward. So that is a lot of material very fast. And I do want to turn it over to Troy now, who's going to take it over from me saying, once that order's in place, what really happens next? So Troy, lead us through that part of the discussion.
Thank you very much, Gwen, and thank you everyone for having me here today. So I know, as Gwen said, there is a lot of information coming here, coming at you, probably scribbling pretty fast, but as we said, this is being recorded, so you can certainly go back and review it. In most cases, as you heard Gwen say, you are not going to be filling out that petition for an emergency or 6-month FRO, firearm restraining order. That's going to be a family member or the police department, but it does pay for you to know what it is and how it operates, how people can access it, because clearly you may be engaged in conversations with clients or people in the public and want to be able to give them the accurate information. So as Gwen said, A family member of the police department goes and they find it necessary. They appear in front of the judge for this, they fill out the petition for the emergency FRO, and the judge will either hear that the same day or the next business day. That's allowed for. So it's a very quick turnaround. This is not something that you could put on the docket and they hear a week or two down the line. That's why it's an emergency firearm restraining order. Once the judge issues it, as Gwen said, that emergency order is good for 14 days. If the police department obtained it, then they're just going to bring it back. However, if a family member is the one who sought that emergency FRO, they are encouraged to go right back to their local police department and work with them on getting this FRO served. Because what's going to happen is the local police department is going to then go to the residence where this individual is located and present them with this firearm restraining order. Because as you heard Gwen say, that's going to prevent that individual, the respondent, the person about whom they are concerned, from possessing, purchasing, having custody or control over any firearms. So they're going to present that order. If during that presentation to the judge, they presented that this individual has access or currently owns firearms, the judge will also issue a search warrant, which then allows the law enforcement agency who's serving this order to recover those firearms. So the family member of the police department get the emergency FRO, they go back to the place that this individual is residing, they present them with the firearm restraining order, that individual then turns over his or her firearms that are in their possession, the Illinois CCL, concealed carry license, and their firearm owner's identification card, their FOID card. All those get turned over to the police who are serving that emergency FRO. The police department then takes those firearms get stored at the local police department for the safekeeping for the period, for the duration of that emergency order, and if a subsequent 6-month order is issued. So they're kept in safekeeping at that local agency. The CCL and the FOID card are then sent by the local law enforcement agency to the Illinois State Police, who will retain that until such time as the emergency FRO and any subsequent 6-month FRO are expired, at which point those will be returned if appropriate. So you can see how this is a very fast process. It's a process for family members or the police department, once they've identified that they feel somebody meets the criteria for this FRO, to go in front of a judge, get that hearing for the emergency order, bring it back, and then get the firearms and the CCL and the FOID card so that that individual can't just go have access to other firearms. So that is what would happen. As you heard Gwen say, that's only good for 14 days. So after that, there will be another hearing set, which the petitioner, whether that's the police department, the family members, can then reappear in front of the judge with the respondent if they so choose to contest. And the petitioner, being the police and or the family members, are going to say, hey, we're concerned that this needs to be extended for a period of 6 months. We need a 6-month order. That's the longest it can go. In which case, as you heard me say, the police department will retain the firearms and state police will retain the CCL and FOID card. So that's what you can kind of expect. If you're hearing family members ask about it, or you're speaking to someone, that is the way the process works, and that the way it would be from the law enforcement response perspective. But I'd like to back up a little bit. Instead of addressing the issue once it gets to the point where we are already at this juncture, where we have an FRO, we feel that it's necessary, I believe that you as counselors, and really truly all of us, family members in the community, can do things before an event, pre-event collaboration, pre-incident collaboration, right? And I think webinars like this are a great starting point for that. You all have taken some time out of your schedule to learn a little bit more about it. And let's face it, when you went to school and got your training, this is not something that you probably thought that you were going to be learning about, right? But kudos to all of you for going out and getting this information. What I'd like you to do is just continue down that road. First thing, reach out to your local police department, or encourage the family members to do that, to find out what it is that they can do. What are their capabilities? And by the same token, what are their limitations? So for example, within the confines or with regard to a firearm restraining order, how would that local police department prefer or like your family members, or you, if it's something that's happening at your office, to respond? How would they like to respond to this? What are their capabilities? How would they like you to handle this? Would they like you to come in as soon as you get it, plan ahead? Would they like you to call the residents? Are they going to say, hey, we have to know so many hours ahead of time? We really want to find out what their capabilities are, what their limitations are on serving this, so that when this time comes that this is going to be served, everyone's on the same page. The family members who are seeking the FRO know what the police department can and can't do, what they expect from the family members, so that things go smoothly. As well as what's required for the firearm restraining order, because that's information that you're going to want to get from your client, from the family member, or have the family members get so that they can present to the judge. So we just want to avoid those conflicts. We're thinking ahead where if this FRO is necessary and the police are going to respond, how are we going to handle it? How can we work best together? So that's the first step. So what is your role as a counselor individually? And that's why you're here. First and foremost, I have to say, you guys are in the best position to be assessing your client, right? You know better than anybody. Are they rising to the level where they are a danger to themselves? They're a danger to others. They can't care for themselves and take care of their basic physical needs. So that's going to be important information. That having been said, going forward, everything I say has to be funneled through. You have to operate in accordance with federal and state law. You have to operate according to your professional standards, mandates, and regulations, your internal policies for whatever organization you work for. And I'm going to also say internal legal advice. Consult your legal advice. And I think Gwen said your carrier is another one. So you have to operate within all that, because it's different, and I can't just make a blanket statement. So when you assess that your client is getting to that point and you're operating under all these regulations and laws, and you find that it is necessary to contact law enforcement, what do you do then? Because when I was in law enforcement, there were plenty of times that we got calls and we would respond to a therapist's office or a psychologist's office, et cetera, to help interact. Again, within the confines of what's legal, ask for a CIT officer or a mental health trained responder. Many police departments have CIT officers. They're officers that receive special training. They're better able to interact, recognizing signs and symptoms, know the laws in the Illinois Mental Health Code a lot better. So you want one of them. And if they have co-response, licensed clinicians who may be able to respond with the officers. So just ask for a CIT officer and mental health trained responder, if you can do that. Provide the dispatcher with as much information as you can, and just say, you know, this is my name, this is where we are at. And I'm looking, state what your intended or your desired resolutions. So say, this is who I am, this is where I'm at, this is what I would like to see done. I have a client here who is threatening suicide or has attempted to take their life. I need an emergency response to the hospital, or whatever the case is, so that the police officers and emergency responders know exactly what it is that they are responding to. Then when the officers get there to the office, or if you are talking to family members and family members are saying, hey, what can I do? Again, provide as much information as possible to help the first responders get the best help for the person that we're calling about. So if we know what mental illness they have, are they diagnosed? Are they taking medications? Are they in compliance? These are things that family members can share with law enforcement. If you reach one of the exceptions and it's advisable under law and allowed, and you can do it if we're called to your office. You heard Gwen speak about some of the things that are required for the FRO. So that's what family members are going to want to share with police officers. Did the individual make threats? Are they threatening themselves? Are they threatening to take their life? Suicidal statements? Are they threatening others? Is there a use of firearms? Do they have access to weapons? Are they under the influence? Do they have a history of substance use? Do they have a history of self-harm? Are there physical indicators? Are there signs of physical injury from previous attempts at self-harm or suicide attempts? So when law enforcement responds to a home, those are things that the family member can relay to law enforcement, because that is then information that law enforcement can take. And as you saw Gwen go through the FRO, those are things that are going to help establish what is necessary for the judge to see whether or not that FRO should be granted. And it's going to make that best case possible. And I know you heard Gwen say, have that whole separate list available that you can staple onto the back. Great idea. So we're giving that information to the court. We're giving that information to law enforcement, but that's all the information that we want you guys, the family members, to be able to relay so that we get that collaborated response. Because when law enforcement is going to respond, sometimes counselors are saying, well, I'm leery, if it gets to that point, what are the options? Well, there's more options now than ever before. We can't get too much into that today. 980 is new things since July 16th. There are 590 teams, but that's a separate discussion. You may or may not be aware of how that works. But specifically with some concerns about what happens when law enforcement shows up to a family member's home, or if they were to respond to your office, what are the options that these officers have other than arrest? Quite frequently, what you will see them do is engage in a petition for involuntary admission. And I won't get into the legalities of that. You can certainly look all that up, but that is going to say when an individual fits the definition under the Illinois Mental Health Code, they need to be taken involuntarily for psychiatric evaluation because there's a concern that they are a danger to themselves, danger to others, can't take care of their basic physical needs. There's certain statutory requirements that the officer is looking for. All that information that I told you to provide, or the family members provide, that's going to help them to get that petition so that they can get the help for the evaluation at the hospital. Another one that officers may do that they have access to when they respond is the clear and present danger. Clear and present danger form, you heard Gwen go through that, the change in the definitions. That is something that law enforcement is mandated to do when we just make a determination, or we believe that an individual meets those statutory definitions. We fax a form immediately within 24 hours to the Illinois State Police. The Illinois State Police then review the case that we have sent them. And if they believe that the individual meets the criteria under the statute, then they can revoke the individual's FOID card and or their concealed carry license. And so what happens then is the individual gets a letter saying that their FOID card and CCL have been revoked. The local law enforcement agency is notified, and then we will typically make arrangements to get those items from them, as well as any firearms. So that's another avenue that law enforcement has to pursue when they respond. And then, of course, the FRO that we talked about earlier with Gwen. So that's some questions about what is the law enforcement response going to look like, and how can you and or family members help us to respond better. But again, I kind of want to back up a little bit and not concentrate solely on the crisis situation, because I believe that you as counselors and we in law enforcement and community members all have a part to play before the crisis happens. Crisis intervention teams, or CIT, have come to be known as a police program, and that could not be farther from the truth. CIT is a community program, and it is made up of stakeholders from throughout the community: police, fire, hospitals, court systems, advocacy organizations, and mental health service providers such as you all, who are working together in a coordinated team, a crisis intervention team, to better meet individuals in preventative, early intervention, when signs are worsening, or when they're in crisis and beyond. So what I'd like to propose is that we start researching within our communities how we can be more involved. Start by contacting your local police department. Do they currently have a crisis intervention team? Because that's something that you can certainly tell your family members, the family members of individuals who are your clients, that they can participate in. Why wait until the crisis happens? If you have a functioning crisis intervention team that they can avail themselves of, they can talk to the police department, maybe have information on hand at the police department, how better to respond. The police department may have other resources that they can work with this individual and get them connected to that treatment early so that that crisis doesn't happen. So that's what we're looking at, is getting that stakeholder coordination ahead of time, because the earlier that we recognize that these signs and symptoms are beginning to worsen, that maybe they're decompensating and heading toward a potential crisis, if we've got some of these systems set up ahead of time, the better off we're going to be. And it could be as simple as, again, as I said, family members having things on file with the police department. There are systems out there, and I'm not advocating or selling anything, but there are systems being used by jurisdictions throughout the country that operate under the HIPAA guidelines that allows hospitals, mental health care providers to enter information into it that's not visible to law enforcement. It's only allowed to people who are HIPAA compliant or allowed through HIPAA, but law enforcement officers can add information into the system about their contact with individuals. And the benefit to that is that if I, as a law enforcement, have contact with your client, and then the next town over has contact with your client, and we're both entering that information into the system, and you have access to that system, then the next time your client comes in, you're able to pull it up and see that they've had contact with law enforcement on 2 different occasions and what the context of those contacts were. So that'd be beneficial for you. So that's, and again, I'm not here to sell those particular systems, but what I'm saying is this interoperation, this collaboration between agencies, having, law enforcement work with a mental health provider where they're making referrals after they have contact, and they're giving them to the counseling agency so that individuals are getting that help before they reach the crisis. Having mental health providers, such as the agencies you work for, maybe connect with local emergency rooms so that your agencies or organizations are listed as a referral on a handout to individuals who are leaving after being brought in on a petition for an involuntary admission. There's plenty of ways that this crisis intervention team works together with mental health service providers, advocacy organizations, family members, to find when people are beginning to display worsening symptoms, heading toward decompensation and or crisis, so that we can get that early intervention and we don't have that crisis. And that's another part of this, another component of this call that I think it is important. Rather than just looking at the end result when the crisis happens and say, what can we do here? That's very important. We obviously need to address that. But I think we all here know that that usually doesn't happen in and of itself all of a sudden. There is usually a buildup there. And the better that we can work together as a team, as a crisis intervention team, the better we're going to be able to identify some of these worsening signs and symptoms ahead of time and prevent some of these crisis situations from happening. You all understand, and you could tell me better than I, that the earlier we intervene, the more likely successful outcomes and treatments become. The more that we work with individuals in the early stages and develop a rapport and get them to go voluntarily engaging in treatment, the better off the outcomes. And we all know that law enforcement, an emergency room, is not the answer to ongoing or to successful recovery, rather. Continued access to continued ongoing care and treatment is where the benefit is. And I think if we as communities, as mental health providers, as law enforcement agencies, as the court system, as mental health advocacy organizations begin to work together to start identifying these things ahead of time, working together to prevent these crises by connecting individuals to treatment, and then knowing how to interact when these crises develop, counselors and families knowing what's allowed in the courts, knowing what their law enforcement agency can do when they respond, what their capabilities and their limitations are, and how to work best together. I think that's when we're going to get the best results that we're all looking for, because it is about teamwork. And the nice part is, not only does it provide benefits and improved outcomes for the individuals we serve, but all of us are going to end up better off in the long run, because we have family members who are getting the relief that they need because their loved ones are getting the treatment. Police are not responding to these. Fire are not having to make the calls. Emergency rooms are not being inundated with people unnecessarily and being held in beds in the hallway because they're overcrowded. And you all aren't dealing with the crisis situations as frequently, because the tide truly does lift all boats, right? A rising tide lifts all boats. We can all benefit from it. And every single one of you can be part of the change. And I think being here today was a great start to that, learning about what the courts have available, how to access it, how to work within the system and collaborate with one another. And I thank you for being here. And I just encourage you guys to all go out and be part of the change going forward.
All right, so thank you, Gwen and Troy. I know that was a lot of information, and I know there were some questions in the chat. Yes, we will be sending this material over to you via email. I did get a couple of questions sent directly. One of them, someone did ask if revoked is an FOID card reinstated.
I have seen and or heard of cases where that is true. They have to go back through a process. They can, number one, they can appeal it, but afterwards they can always reapply, or I don't know what the appellate process is because that's through the Illinois State Police. So if they want specifics on how that is done, that would be a question directed to the Illinois State Police. But there is an avenue to pursue to have a revoked FOID card or CCL reinstated.
Okay. I did receive another one from Skylar asking, what are their responsibilities to report to FOID/police? Example, if a client is hospitalized for suicidal ideation, do they need to report it to the police or FOID?
Well, the answer is they report it to the Department of Human Services in Illinois. They don't go directly to the state police. Only law enforcement and educators go directly to the police through that form. If they are, in the mental health, and then we have to be very careful because that reporting, and that's why I'm encouraging you in that instance to talk to your carrier, because the only protected areas where it's mandatory is physicians and licensed clinical psychologists. And then they report it to the Department of Human Services.
Okay. Yeah, I received another one here. What are some reasons that you've seen judges refuse to sign a FRO?
Well, I can't give personal knowledge in detail, although I've been doing a lot of reading, and I will tell you that there are counties who are extraordinarily cooperative and agencies with it, and circumstances, communities where they're not as supportive of it. But you can't bypass, and I'm always a believer in this, you go before a judge, you give the circumstances, and a judge carries with them their references to their socioeconomic background and what they see. However, I think that as with order protections, I think the tendency will be, especially at the emergency level, to provide that level of protection quickly. I think you're going to have more difficulty when you get to the extension hearing. And then it depends on whether or not there's representation, et cetera, as to how far the fight goes on. Because obviously you're going to get interruptions for hearsay and other evidence rules that will come into play that could have an impact as well.
Yeah, I agree with Gwen wholeheartedly. And the only thing I would add to that is that underscores the importance of why we need to present so much information on those forms, because the judge, the more evidence or information that you can provide to the judge about why you believe this FRO is necessary, the more they will consider and the more prone they may be to grant it.
I agree with that.
Okay. Another question we received is, if someone in a school or college counselor, do they go to the Department of Human Services or directly to the police?
They can go to the Illinois State Police and fill out the form, because the school is the exception to the physicians and licensed clinical psychologists.
Yeah, and that form, as Gwen showed, is available online. You've got it here, and there's a fax number, so it's very easy to just fill out and fax it. But again, I will tell you from professional experience in submitting those, as much information as you can on that form. I have seen individuals just try to shortcut it and make a few statements like, he made this comment or she did this, and they felt that was sufficient. And then state police is in the position of saying, this is the only thing I have to look at. I don't know that that's enough. So make sure, again, that you're providing as much information as you can on those forms when you fax them in.
Okay. I had another question. If someone is hospitalized, should they call DHS?
I don't think that if they're a licensed clinical psychologist or a physician, they certainly have the right to do it. I think that you have to make that decision. If you don't fall within that, I would contact the carrier, because at that point in time, you're in two situations, but the hospital may notify, they may not. They may not have the evidence that you have that something was imminent or that you heard a direct threat on the life of the respondent or other individuals. So again, I think you have to govern yourself with the capacity to which you work with. And then if you don't qualify for that exemption, contact your carrier.
I did receive a message that I think needs some more training. I will need to know how to work with the CIT team. I will reach out to my local police. And Troy, this, maybe that's something, if your local department may not have a CIT established, I think that might be an opportunity that you could speak to help, direct at that point too as well.
Yeah, absolutely. I mean, my contact information was distributed. I am a certified CIT coordinator, so I coordinated and created the team in my former jurisdiction. I actually do help other agencies to create those organizations. So just remember, it is not a law enforcement organization. They are an important component of that, but certainly an advocacy organization could be the one to start leading that, or a mental health provider. It's just getting the community members on board. Again, law enforcement is an important component of that. You want them on board, but yeah, if you have any questions on how to go about that, feel free to contact me. Another great resource is CIT International. You could Google them, or otherwise it's citinternational.org. And they also have a book that you can purchase. I think it's like $10 or $20 that pretty much goes through the whole thing on how to set up a crisis intervention team.
Thank you. And I'll reshare the contact information again if anybody needs it. I had another question. Do family members have access to a lawyer or legal advocate during the process of seeking an FRO or an order of protection so as to know more about the best way to go about protecting themselves?
No, there's not a free legal service to my knowledge, at least in the counties in which I work. There are advocates, court advocates, but they are not lawyers. They are simply people to assist them. And I think that if you want to have an attorney, because some people would feel more secure to do that, they need to make sure that they're contacting an attorney who has experience in the area of order protections, firearm restraining order, which frankly, you're not going to find a lot of people who do that work. So certainly if a family law attorney or somebody that does mental health law would be where I would direct.
Okay. Someone said, what would be the reason to report to DHS?
Somebody told you that they were suicidal, or they had a plan that they were going to take, maybe workplace violence, and, they're describing to you something, or that you believe that you meet the qualifications. I think that what we're getting into now under the new guidance is the situation where they communicate a serious threat of physical violence against a reasonably identified victim, or they pose a clear and imminent threat, risk of serious physical injury to themselves, another person. It can be threatening. Like I said, it doesn't have to be under the new standards. And again, we're going to have to revisit this because we have 150 days to see if this emergency order sticks from 7/18. So we got some laws here, basically to almost the end of the year. And at that point, we'll have to review to see if what the conclusion was as to how to address this. But for the time being, those are the situations when I would do a report if you meet the definitions. If you don't, and you're a licensed clinical, counselor, whatever your license is, but you don't have the physician title or the licensed clinical psychologist, again, and it's for your own protection, contact your carrier to say this is what you're going to do. Or know the risks that you're taking on, because you can be divulging confidential information about your client. Now, your client is not supposed to learn who made the report, but as we all know, things happen. So I always suggest that you proceed with caution. And my job as an attorney is to make sure that I'm giving you standards that are compliant with your responsibilities.
With that being said, we did have two people asking if by carrier you meant their insurance carrier for their practice.
That is correct. Yes, they're carriers.
Yes. And then I did have a question.
Yeah, I'm sorry. Your carrier will then refer you to an attorney if there's other specific questions. And you have the ability to have that type of coverage. Okay, go ahead. I'm sorry, Kelly.
Oh, no, and Gwen, and you are the attorney, not I. I believe HIPAA also makes an exception for when an individual is deemed to be an imminent danger to themselves or others. Is that not correct?
Well, HIPAA does, but the issue is that our Illinois Mental Health Act specifically identifies the two categories as well and makes it consistent and refers back to the administrative governing body that creates the regulations for the FOIA cards. So FOID cards. So, it's a circular argument. That's why I suggest that you proceed with caution on that.
Someone asked if we could review the changes to the definition of clear and present danger. So yes, in the link that you'll be emailed out, we do have the older version with the amendment added on towards the end of it. So you can see the changes in that as well. Let's see. I did have someone say, I used to work at London Oaks. I know there is a way to get your FOID card reinstated. There is a form to fill out, and then you have to have a psychiatrist fill out a form as well, agreeing that you are not a risk to yourself or anyone else. It is not easy to do at all, and my impression is that you have to fight the state a lot of the time.
And the answer would be, now that they can retain records from the past, I think it'll be a lot more difficult, where before they couldn't retain information. So hopefully, not hopefully, we'll see what happens with this emergency rule change.
And then I had another question, but by care, you mean the malpractice insurance provider?
Yes. Mm-hmm.
Yes. Okay. And then Lisa sent a message. Thank you for this information, Kelly, Gwen, and Troy, and she looks forward to sharing with her team. So thank you, Lisa. I had, what about when threats are vague, such as I'm going to shoot some people with my gun?
Okay, I get it. I have been in that situation. I've been practicing family law for 33 years, and I've heard many times, I just want to kill her, or, and you have to interpret it as, are you really serious about this, such that I need to call the police here? As an attorney, I have the same struggles that you guys have, or is it jesting or whatever? And that just comes by your instinct and everything else that you know about the person, which is why, listen, confidentiality for both attorneys and for Illinois Health, or, our mental health providers, it's key to the system. So that's why there's an exception for physicians and licensed clinical psychologists. In that case, I would turn it in. If not, I'd proceed with caution. But I think that we all can be creative. Let's talk vaguely about, or generally about it. One is, you could potentially draft a release, early on, that that might be something that you would consider, that if you felt that they made a threat to others, you have to evaluate it. You don't want to be the one responsible if they went out and acted. Also, having an emergency contact, having something that becomes a formula that you notify the person that if you get in that situation, that's what you may have to do, may be a way and a solution for you to approach it as well. So I get that it's difficult, and it does call for somewhat of a judgment call, because we all know that people jest, and I just want to kill her, or I would like to smack her right now in the face. Is that a serious comment? Is that an imminent? And again, they're removing the word imminent and giving more discretion. So that's where we're at. These things are hard. I didn't say they were easy. And that's not making light of it. It's a serious, serious topic. And it's a hard act to balance confidentiality for the sake of our respective professions, and revealing the information to protect society at large, which we have a duty to our community as well. So I see both points, and that's why I brought Troy in, is that I think sometimes we have to do this balancing act, and the better off we are is when we all come together.
I have another question. How do we make sure that we are using the FRO as it is intended, so that it does not violate someone's rights?
Well, isn't it the judge's job to determine whether or not there is enough information or not? I mean, I think that at some point, that's what I tell people, in another situation is, are you going to win or are you going to lose? I don't know. I don't have a crystal ball, but what I can tell you is you're going to do everything within your power to try to prevent this. If you take it to a judge, you can't control the other person, so that person has to make that decision. Troy, do you have any other advice on that? Because I think we don't have all the answers.
No, and I agree with you. You're not going to be violating any of their rights, because, as Gwen said, the judge is making the determination. I would say err on the side of caution with that. And, you all have conversations with the family members of the clients that you see, or you could encourage, whether it's through a family session or however you have access to that. And again, operating within the confidentiality and the laws and the mandates that you have, just suggesting to them that, if they're having those concerns, there's something there. And that is a great opportunity for them to be working with the crisis intervention team. It doesn't have to be all on them. But certainly if they believe that they have some, even if they don't want to contact the police department, they just want to do it themselves. If they have any concerns whatsoever, list them all out, make sure you have everything, all your supporting documentation, whether that's video clips, audio clips, pictures, whatever, and tell them, bring it in. The judge will make the decision. If the judge decides that it's warranted, then he'll grant it. If not, he or she will not. But you're not going to be violating rights in doing so. Not that I see anyway.
Not sure if anyone else had any other questions. I think I got through them all. And if I did miss it, sorry, there was a lot coming in here, so I apologize.
Well, thank you for the opportunity to let us talk and discuss this topic. You know, as I indicated, we're now creating brochures, understanding that we've got duties we got to make sure. And I'm sure that you've heard enough about, you know, things that you have to think about, and, you know, your plate gets fuller as time goes on. These are situations we all have to address to some extent. So thank you for having me. And on behalf of Troy and Kelly, we appreciate it. Troy and Kelly, anything else to add?
No, thank you again so much. Again, as I told you in the presentation, great first step, you guys being here, getting this information. I encourage you to get as much info as you can and be part of that team to help the individuals who need it the most. So thank you very much for the opportunity to be here.
Yeah, thank you so much for presenting with us today. Thanks, Gwendolyn, Tony, and Kelly. You know, it's a needed topic, and I'm going to send an email out to everybody with the information, including the presenter information, the handouts, your contact info as well, and the evaluation. So thanks for sticking around, anybody that wanted to get some of those extra questions in. Thank you for attending, and have a good day.
Thank you.
Thank
Thank
you.
you.